Hello everyone, and welcome to today's webinar, Immigration Enforcement and Employment Verification in a Time of Extreme Vetting. Before we get started, I would like to go over a few items so you know how to participate in today's event. You have joined the presentation listening through your computer speaker system by default. If you would prefer to join over the telephone, just select telephone in the audio section of your control panel and the dial-in information will be displayed. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions box of the control panel. You may send in your questions at any time and we will address them at the end of the presentation. I would now like to introduce today's presenter, Peter Guattery, partner at Whiteford, Taylor and Preston. Welcome, Peter.
Thank you. I'd like to welcome everyone to the presentation today. I'd like to think this is a very timely topic. I have debated as to when the best time to present it is based on all of the events that have been happening, and I'm glad to have finally gotten something put together and have all of you here joining me today to discuss immigration enforcement and employment verification. It is, as I'm sure you're all aware of, a very important topic, particularly with the changeover that we have seen in both in rhetoric and in action with respect to employment verification and immigration compliance and ensuring that employers only hire documented workers and lawfully authorized aliens for their employment. And I'm going to cover several different subjects today. I am not going to cover how to fill out an I-9 form. I will touch on some issues in the context of completing an I-9 form. However, I will not go through the basics. That is something that I hope everyone has at least a general familiarity with. And then I will talk about the audit and enforcement process, which is regulated by the Immigration and Customs Enforcement, or as we call them, ICE, which should be a very endearing name for an organization which could be the bane of your existence at some point if you have issues with I-9 forms. And then we'll talk about measures to protect yourself from ICE, including audit programs and the like, to allow an employer who has already undertaken what it needs to complete its I-9s to go back and ensure that their process is working and that their forms are accurate and complete. So with that, I'd like to move into basically the form, which used to be a single page and was called the most difficult single page form in the world, but is now multiple pages, and particularly with the latest revisions. But still is an extremely difficult form, not solely because of the difficulty in the information that is required on the form, but also as to the consequences that can flow when that information isn't correctly provided or not provided at all. So let's talk first about the I-9 form itself. This form has seen multiple revisions. The most recent revision was in July of this year. However, there was a significant revision to the form in November of last year. This form, and I'll go through what changes there were made to it, came out around November 14th, which coincided with another date, which I'll discuss in a moment, with a mandatory use date of January 21st, 2017. In addition to that new form, which has some new fields and which was intended to clarify and improve the ability to use the form, it included a smart form. Now, this is a form which I'll discuss in just a little bit more detail in a moment, but this form is an online fillable form that actually helps you as you go through the form to complete it. In addition to this new form in November of 2016, the instructions were more than doubled. They now comprise 15 pages of detailed instructions, which were intended to help employers understand the requirements of the form and how to complete it. Now, that doesn't mean that everything has been answered, okay? And they still had to make changes in July of this year with respect to some issues that had come up in terms of the availability of documents which should be ordinarily given to somebody when they arrive in the United States. Now, on top of this, and we'll talk resources at the end of the show, but one of which I want to mention to you now is the M274 Handbook for Employers. This is a significant document. It's quite long. It's quite detailed. It tries to answer as many questions as you may have about the I-9 form, and it tries to provide very helpful guidance regarding the I-9 form. It was updated in February of 2017, which, as you note, is a month after the fact, or almost a month after the fact of when the new form became active. And there have been subsequent additions and changes to this form. However, it is an excellent source for answering questions about the I-9, and it's something that you, as somebody responsible for I-9 compliance, should read and should have ready as a resource if questions come up in preparing the I-9 forms. The only caveat I give is that sometimes the advice becomes outdated because of changes, either in the law or in the form, and sometimes there is guidance given which may clarify issues that are in the M274 handbook which aren't altogether clear. What I can tell you as an immigration practitioner is that the variety of documents and the situations in which individuals may be work authorized or in which their documentation may be available but they don't know it or they haven't received it are significant. And oftentimes, if you have a conundrum, then the last resource is guidance, and guidance probably from an immigration attorney, preferably one who's a member of the American Immigration Lawyers Association and has access to their excellent resources in this area. So let's look at what changed on the I-9 in November 2016. I've already mentioned the instructions being expanded. They are now separate from the form, okay? However, keep in mind that the document list is part of the form, and that list must be given to the employee when the employee completes their section 1 of the form, on or before the first day of employment, okay? So that is something you must bear in mind. Also, the instructions must be available to the employee when they are completing the Form I-9, the Section 1. So you'll have 2 documents which will be given to the individual. There have been changes to Section 1 to address the delays in the issuance of electronic I-94 records. Now, for those of you who don't know what an I-94 record is, an I-94 record is a record of entry of an individual into the United States. That form used to be a small white or green card that was stapled into the passport upon entry. And it bore a stamp showing the date of entry, and it also had an indication as to the person's non-immigrant status, or in some cases immigrant status, and a reference to their period of authorized stay in the United States. Okay? That changed several years ago when the switchover was made to having electronic I-94 records, and now every alien who enters the United States has a record of entry that is electronically entered. And the individual would have to log into I-94, I forget the exact website, but you can just do an I-94 record of entry and you'll come up with it. That information will be available to the employee by entering in their passport number, date of birth, and name, and they can print out their entry record, which they should do, okay? But there was originally a delay in doing that, so there were changes made to Section 1 to add the foreign passport number in Part 3. Now, typically, that will only be completed as a basis for work authorization, where the individual has an I-94 that shows they are going to be in a particular status, such as J1, H1B, O1, L1, for example, that authorizes that person to work for you as the employer. Otherwise, it would not necessarily be an acceptable reference. And I don't want to mistakenly give the impression that anyone with a foreign passport can fill that out and their work authorized. That is not the case, as we'll discuss later. Another change that was allowed is to let employees use a P.O. box for the address, but not employers. They recognize that in some cases, employees may have a post office box as their address and will need to enter that. On the fillable form, and I recommend also with respect to the paper form, if you're using it, all spaces need to be filled in. If you're using the smart form, you can only fill in the next box if you put something in the box prior to it, which means you'd have to click NA and enter that in the space. Another addition was in Section 2 to add in a requirement before entering the documents that the employee's info from Section 1 and to indicate their citizenship and immigration status. Now, there'll be a drop down on a smart form, but you should be, if you're not using the smart form, you're going to be using whichever category they ticked in the box in Section 1. And now employees are also required to identify affirmatively whether they use a translator or preparer. And if multiple translators or preparers are used, which is a possibility in some cases, then a supplement is provided for that purpose. Keep in mind, the Spanish language version of the form is not for use in the continental United States or Alaska and Hawaii. It can only be used in certain possessions, including Puerto Rico. So you're not going to be able to use the Spanish form in the continental United States. And I have seen it used simply because people assume that's what it's there for. It is not. And the handbook itself should make that clear to everyone. Another change, which I really like, is the new field in Section 2, which may be used to document continuing work authorization for certain foreign nationals. For example, in many cases, an employee might have work authorization which has an expiration date. However, USCIS regulations will permit, if a timely extension is filed, that person's work authorization will continue for a specified period of time while the application is pending, provided it was timely filed. And this is a box in which that very information can be provided. That happens with STEM cases, for instance, where somebody has what's called cap gap, which is between the time that they have filed for an H-1B visa, which would come due in October, and the expiration of their optional practical training, which is what they get if they're a student, which may be sometime after April 1st. If there's a gap, that period of time would be work authorized once the H-1B is approved, and you would make an annotation in the additional information box to show that. Similar with H-1Bs, where a timely extension is filed, they have up to 240 days after the expiration of their work authorization, in which they may be employed by regulation, waiting for that case to be adjudicated. So this is a box that can be used for that kind of information. Section 3 includes changes that require including the last name, first name, and middle initial of the employer from Section 1. Re-verification must be done on the most current version of the form. And for a rehire, that is somebody who's coming back to you after no more than 3 years, the employer can use Section 3 or a new form if they wish to. I wish to emphasize that the SMART form is not an electronic I-9. It's a tool simply to assist you in completing the I-9 form. And you need to be very careful to ensure that you print it out with all the answers, that they're all correct, and that the proper signatures, both from the employee and the employer, are on the form. You cannot download or imprint a watermark signature of some kind to this form. It should be an original signature. Outside the scope of this I-9 is the use of electronic I-9 systems. That is a seminar unto its own as to what would be appropriate for use and how those are regulated. But I want to emphasize that this is not an electronic I-9 form. It's just simply a template you can use, and you still need to print it out. There have been some technical issues on it, most notably with Social Security entering the Social Security number. Those have largely been corrected. In July of this year, there were some additional changes, merely changing the type of documents that were allowed based on some additions to permissible documents, and then renumbering List C documents. Those are not substantial changes. However, it's important that you use that form now. It became mandatory in September, and that will ensure that you have the most current version of the documents that are acceptable available to you and to the employee. Okay. Now, what are some of the tricks and traps of this I-9 process? Well, there's the H-1B visa, which has a 10-day grace period added to it now. And what that means is you might get somebody with an I-94, which has additional 10 days beyond the date that you requested for their work authorization. Well, those additional 10 days are the grace period. They're not periods in which the person is work authorized. The work authorization is the period of time for which you asked for work authorization in your application and is shown at the top of the I-90 or top of the approval notice for the H-1B. So you should be wary of that and make sure that you don't enter the 10-day grace period as part of your the employee's period of authorized employment. The expiring green card is another trick. People say, the green card's expiring, you need to re-verify it. The answer to that is no. Green cards, if valid, appearing on their face, never need to be revalidated. They are considered acceptable work authorization documentation, period. And this holds true even with persons who have conditional residency status based on a marriage to a U.S. citizen. Asylees and refugees when they are admitted in this status or they gain this status in the United States, have what is called work authorization incident to status. That means the very fact that they are asylees and refugees gives them work authorization. They may have a work authorization document which permits them to work during a certain period of time, but they're also, because they're asylees or refugees, authorized to work in any event. So I actually had a case where an individual was terminated because they couldn't provide evidence of renewed work authorization, and they were an asylee. And when it came to me, I explained this quirk in the law, and we had to reinstate the person and give them back pay. There wasn't really any other way about it. The Department of Labor enforced that in enforcing a document violation claim by the individual. TPS are people in temporary protected status, and their extensions are usually done by the Federal Register. So they won't necessarily get a document. They'll get a employee who tells them, hey, they just extended it, and you'll have to get the register citation and annotate their form to identify the extension on their behalf. Another problem area is the receipt rule. This only applies to lost, stolen, or damaged documents. It doesn't apply to somebody who's filed for a benefit and has a receipt. I can't emphasize that enough because that is the question I repeatedly get, and then employees are trying to pull on you by showing you that they've applied for a benefit. All that means is they've applied for a benefit. It's not work authorization, and it's not covered by the receipt rule. And then the last one, and there's many more, but these are some ideal ones that I picked up. One of them is to copy or not copy the documents. And I'll discuss this in a little bit more detail. There are benefits to it, and there are downsides to it. My inclination is oftentimes, if your workforce isn't of the kind that will produce questionable documents, it's probably best to do the I-9s as thoroughly as you can and not collect copies of the documents. If you are not in that particular situation, then it's probably a good rule of thumb to keep the documents just in case there are questions that come up later in the audit process. So let's move on to ICE audit and enforcement. What exactly are we looking at when we have an ICE audit? There are other types of investigations that you may find yourself in. If you employ an alien in an H-1B status or an L-1 status, which is an intercompany transferee, you may get visited by the Fraud Detection and Notification Service, the FDNS. They are totally different from ICE. And they're part of Department of Homeland Security, but they're out there looking for fraudulent abuse of the H-1B and the L programs. What ICE is charged with is auditing the I-9 forms. Now, the Department of Labor can do this in connection with an audit of your wage and hour compliance. I've only ever had that happen once, and curiously, it was a rather questionable request from the DOL audit investigator, which we were able to sort of sidestep. However, if ICE comes in, they're going to come in with probably two people, one of whom has a badge and will show it to you, and they will deliver to you a letter telling you that they want to inspect your documentation and you have 3 days to produce them. So how does this process work? Well, the notice of inspection is the document you're going to get at the beginning. They're going to hand that to you and you'll have 3 days to produce the documents. That's a seriously important timeline, because if you don't produce your documents in 3 days, you can be subject to penalties for every document not produced. So if you have 100 employees, that's 100 violations for failing to produce in a timely fashion. And those can add up, as we'll see, significantly. Okay? So when you produce the I-9 forms, and they will take the original forms, okay? In the context of an investigation that is criminal, they will come in with a warrant and they will take your I-9 forms. You will not have the 3 days necessarily. But they will come in if they have reason to suspect there's a come in. They will come in and they will get the forms that they want. But we're talking here just about civil enforcement, and they will ask for those I-9 forms, and you will give them all to them. Now, preferably, there is time to copy all of the documentation so that you have a record of everything that you handed over, because you're going to need to give this to your counsel so that he or she can look at those documents as well and give you a heads up as to what potential issues may be. Now, it takes ICE some time to look at the documents. Now, I'm talking from experience that I've had working with ICE here in Baltimore. I can tell you that ICE, depending on the regional office, will vary greatly in their approach. Some offices are very aggressive. The Baltimore office, I have found, knock on wood, is a cooperative office. They are helpful to work with. They are looking to make sure employers are in compliance, but they're still going to fine you. So you have to keep that much in mind. Now, typically what will happen is you'll give them the I-9 forms. They will look through all the I-9 forms, and they will tally up by the section of the form and by the type of violation, and they will oftentimes they will explain ahead of time briefly what they see, but they're not going to say much in detail until they'll set up a meeting with you or your counsel or both to deliver a document, which would be either a notice of discrepancies or a notice of suspect documents. If there are no violations at all on those I-9 forms, and I've had one case where that happened, not a single violation on the I-9 forms, they simply sent us a compliance letter and returned all the I-9 forms. But if there are problems, you're going to get documents which tell you what the most likely ones are going to be notice of suspect documents, which are individuals who they suspect have documents which do not relate to them or are not lawfully issued documents by USCIS. It's a false green card, it's a false employment authorization document. Notice of discrepancy would suggest somebody in your workforce is using a false identity. They have borrowing the ID of another person. In addition, you're going to sit down with the ICE officer. And again, this is Baltimore, not others. Others might issue you a notice of intent to fine with the violations listed first. But in Baltimore, I would get a listing and sitting down, in addition to the notice of suspect documents, I would get a list of the violations that have been found, what sections weren't completed, how many times they didn't fill out section 1, how many times they didn't fill out section 2, where are A numbers missing, where are boxes not ticked, etc. In that situation, what has typically happened in Baltimore is that they'll permit us a period of time to deal with the notice of suspect documents, deal with the notice of discrepancies, and once those issues are addressed, then we'll engage in further discussions to see if an agreement can come to regarding a proposed fine. Now, when I say a proposed fine, that would be something that would be sent up to the Office of Chief Counsel for review, and then it would subsequently issue a notice of intent to fine, or if they're not going to issue any fines, a warning notice. I've not encountered that in almost every case where there's substantive violations. There's a notice of intent to fine. Now, typically, with the notice of intent to fine, if we've come to agreed upon number and that number stays the same, then it's simply a matter of, once that notice is issued, paying the amount and having a final order issued in the case, which will close it out. And there are a lot of technical issues to negotiate in that context. I don't want to get into all of the variations of it, but I will just mention it to you so you at least have a basic concept of the process. Now, what are we talking about when we get into IRCA violations? And that's the Immigration Reform and Control Act. We have technical violations, which could be using the Spanish form, the employee failing to list a maiden name, failure to include an A number. These are things that are readily correctable on the form, okay? And typically in the context of an investigation, at least here in Baltimore, I would be told what the technical violations are. I'd write down the list, and then I'll tell the client, and they'll all get corrected, and we'll give verification that they've been corrected. That would leave the substantive violations, which are where the employee fails to tick a box, the employee fails to sign, the employer fails to sign, the employer fails to record any documentation whatsoever as having been provided. And now there's a catch there with that. If you do copy the documents and staple them to a form and everything else is completed, with respect to Section 2, CIS and ICE will consider the failure to complete the documentation section, part of Section 2, as a technical violation, but only if the actual documents are there and they can look at them and say those are valid documents. Okay? Then there's knowing hire, which is when you have knowledge or should have knowledge that somebody is unauthorized, and continuing to employ, which is when somebody you know were told previously they're not authorized and you continue to employ them. In the interest of time, I'm going to skip the criminal violations, but I think you should be at least aware of, from the context of harboring and encouraging, and that is when you know somebody is not lawfully authorized to work, and you either provide assistance or aid to them in getting a job, you don't have them complete and fill out an I-9 form properly when everybody else has done so. You may provide them, for instance, there have been cases where all of the workforce has been found sleeping in the basement of an employer's house. That could be harboring. And then there are a variety of other crimes. These are just a short list of fines. Transporting would be picking up people and moving them from one location to the other, knowing that they're not lawfully authorized to work. And these can land you with serious criminal penalties. Now, remember I said back November 14th was a significant date. Well, also what happened at the time is a new penalty structure went into effect. And these penalties have been doubled. They are now twice what they used to be, and they are substantial. And I can tell you, you say, well, what is it that decides whether a paperwork violation is $216 or $2,156, okay? And that can be in a first offense. Well, what matters is how many of your forms have those paperwork violations on them. And the percentage of forms that have those violations on them is going to tick up the amount of the fine. You have to look for it, but it's on the Immigration Service website. But they have a matrix that they use to apply to determine where in that range from $216 to $2,156, where in that range they apply that penalty. And also for the unlawful employment of aliens, which is where they can show you have unauthorized workers, those fines will go up. Now, fortunately, I have not seen this as a significant issue with respect to the Baltimore office, as long as you're willing to take steps to address those individuals listed on the notice of suspect documents and terminate them where appropriate. And again, they work with you within reason. Now, they will also, they being ICE, will also impose an enhancement matrix onto your total penalty. They'll run the numbers and they'll figure it all up. How many violations of paperwork, what's the total percentage, where they fall in the range, and then multiply those numbers together, and then they will add and reduce that based on these factors: business size, good faith, seriousness. You know, if you have a lot of missing I-9 forms, +5 to that number. Okay, if you have a lot of unauthorized aliens, more than half your workforce, +5%. Okay, if you have a prior history, +5%. You could see that number adjust up by 25%. The problem with that is the numbers are very high now. If you have a workforce of 100 and you have an average fine of $1,000 with a 25% enhancement matrix on it, well, that's a substantial amount of money that you're talking about with respect to fines, and that's not where you want to find yourself. Other sanctions that get imposed: asset forfeiture in connection with criminal proceedings. You could be debarred from a federal contract if found to be employing persons without work authorization. This is why, when we're looking at negotiating a settlement of a case, we want to try and avoid anything on the form which identifies an unlawful hire. They will use their form, the notice of intent to fine. That's going to be the basis. If you're not going to litigate, that's going to be the basis of your violation. And that has to have a specific reference to the statutory section you violated. You want to make sure that that's not on there. But if it is, you could find yourself barred from federal contracts. And then some states impose sanctions on their own. Virginia, for example, where public money that might be available to you in connection with work projects, et cetera, may not be available because of your immigration violation. What are some of the common violations that we've talked about? Failing to tick any box in Section 1. Failing to include the date after a signature. Failing to complete the I-9 process within the 3-day window from the start of employment. The first day the employee's got to complete Section 1. And it must be fully completed. You have to make sure of that. Within 3 days, the employer has to complete by reviewing the documents. And that means looking at the documents, okay? Actually reviewing those documents to see that they appear to be genuine and relate to the individual. Now, that doesn't mean you have to be a document expert. It just means that you should be alert to issues on the documents which are potentially problematic. And that appears ones that look irregular. I have seen documents written in crayon, okay? That is an irregular document. I have seen documents with clear misspellings. Citizenship and Immigration Service is spelled fits in service. Those are false documents. I have seen it where If you put a ruler along the line, you can see that the text clearly is not level. That's a false document. So those are things that you should be aware of. I've seen things where the pictures are blurry or dark and not necessarily, those could raise questions. They may not necessarily be unacceptable documents. Failing to properly list documents or thinking photocopies are a substitute for completing the form. I know I said that this can get you only a technical violation, but please fill out the form. Fill out the form as carefully and completely as you can, because simply makes your life easier down the road when dealing with ICE. As I said earlier, the one client I had who got a compliance letter, it was because even though they had copied documents, everything was absolutely spick and span perfect in their I-9 forms. They did an excellent job, and that's because they trained their managers on how to do it. Another one is the employer not completing the attestation in Section 2, failing to include the date in Section 2. There may be some defenses to that, but that's something you really have to make sure you're doing. Not following up on expiring or expired work authorization documents. You should have a tickle folder that tells you when employees have expiring work authorization. You should know 100 days out, and you should tell them. And you should follow up on 90 days out, and then 60, so that these employees know that their work authorization is going to expire. If you have a question about it and you're not sure where to go to counsel. Not personally inspecting the original document. You have to look at the original documents. If you're hiring somebody remotely, then you're going to have somebody remotely look at the actual original documents. You can't look at a PDF. You can't look at a scan or a fax. You have to look at the original document. And another one is using old and expired versions of the form. Now, I have a document or a note down at the bottom there about document abuse and discrimination provisions. And I want you to be aware of that because, quite frankly, you cannot select the documents the employee picks. They get to pick. And you should be careful ensuring that that's the way it's done. You should also be careful that if there's a document the employee insists is acceptable and you have questions, go to counsel. You could be charged with discrimination or document abuse for refusing it. Bear in mind, people living in Puerto Rico are U.S. citizens. They don't have green cards. They would have evidence of U.S. citizenship they could present to you that would show work authorization. They may not have a passport, but they would have a driver's license and a social security card. Enforcement activity. What are we looking at? We're looking at the present administration looking up to hire 100,000 new agents. Okay? What do we know? Well, we know that enforcement activity this year is already up substantially, almost triple. In the period between 2009 and 2014, there were 13,000 inspections. Okay, that's a 5-year period or 6-year period, and already this year we've had over 3,000 inspections from immigration, from ICE offices. So that's a significant increase. And also we know that the penalties are higher, and we know that the courts are enforcing the higher penalties, and we know that ICE is being somewhat more difficult about mitigating those penalties. So this is something that really is significant. And while the news appears to show current activities are focused on individuals, don't discount employer-directed enforcement activities because of the size of these fines. Acting Director Tom Homan just earlier last month said that you can expect as an employer an increase in I-9 inspections by 4 to 5 times, which means you could be looking at 6 to 8, maybe 9,000 inspections over the course of this year and next, which is substantial and really puts you, particularly if you're in a target industry, in the crosshairs. So now that I've thoroughly scared you to death and you're all scrambling to get your I-9s and see what's wrong with them, what can you do to protect yourself against ICE? Well, the most important thing, and there's one subsidiary of this has to do with if you get rated, and that's a different topic, and there should be a different plan in place for that. But from an I-9 standpoint, your best defense is developing a compliance plan and an audit procedure. And that means you're really going to have to sit down and think about it. You're going to have to look at the form. You're going to have to look at the M274, and you're going to have to draw up a process for how those I-9 forms are completed and how re-verification is to be done, and spell out each step of that process. Then you should identify, if not by name, then title, who is the responsible person for doing it. And then make sure, there might be 2, there might be 3, you might have stores, okay? I know a franchise where they have multiple stores, and every single person who's a manager of those stores is responsible for doing the I-9s in their store. However, they have to send a complete copy of their I-9 when it's done to the corporate headquarters, where an HR professional who is trained will review it. And all of that is done within the time frames because they have a process set up so that the corporate knows when somebody's hired. They ask for the I-9 within, they say you must provide it by this date. If they don't get it, they follow up. Once it comes, they review it, and if it's okay, they will okay it. This is a very detailed process to make sure it's done properly. If there are questions, you're going to have to look at USCIS publications. You ought to get those ahead of time. Know what's available to you, okay? Set out a process for maintaining your I-9s. Don't ever keep them in your personnel files. No, 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 absolutely not. I-9 forms should be kept separately. They should be separated by current and terminated employees. The terminated employee file should be maintained in a way so that they can be discarded in accordance with the time frames that are allowed by law. And the current one should be maintained as well, available for an audit or inspection as necessary. And all of them should be kept under lock and key because you have valuable information in there that could result in identity theft. If you maintain them electronically, you're going to have to make sure that you have a process for recovering them and having them available should you get an audit within 3 days. If you don't, you can be fined substantially. And there was a company out in the Midwest which received a multi-million-dollar fine as a result of that, even though they had them all completed, and even though they had an electronic system that worked, they couldn't print them out and give them to ICE in time. Identify a chain in command. Who's going to be responsible above the people filling them out? Who's going to make the final decisions? Okay? And then set out an audit process. Now, your audit program is not mandated by law, but if you look at all the CIS literature, you will find that it is something that they harp on quite regularly as something that you could do. And an audit process will, an audit program is something that can help you in being evidence of good faith for the mitigation factors we talked about earlier. It'll enable an employer to identify and correct technical and substantive errors before they get to ICE. If ICE sees that you've corrected it, then they're not going to fine you for it. Okay? And an audit program should be written and provide clear guidance for each step of the process. So what do you ask? Well, how often are you going to do it? Annually? That may be a bit much for a small company, but that might be required for a large company. Every 2 years? All new hires within 2 years? You have some leeway in doing it, but you're not going to do it based on whether somebody has a Hispanic surname or not. Because if you single out a particular group, an ethnic group or classification for an audit, then you're going to be potentially hit with discrimination and retaliation suits, and you want to avoid that. Who's going to review them? You might want to have somebody independent of the person who completed them, but any corrections would necessarily want to be made by the person who completed them, so that you have at least an independent review and an assessment. I personally have reviewed forms and then sat down with a client and reviewed my issues with them. And then you have to develop an idea as to how you'll address problems with documentation. Missing documentation? What if there's no documentation? What if you fail to complete section 2 and you didn't photocopy? What if the documents that were provided are funny looking, okay? What if you got a Social Security mismatch letter with that employee and their form? Those are things that you're going to have to think about and how to address them, okay? What to look for. Well, is it the correct form? When was the employee hired and what form was current? You can find that out by looking on USCIS website. Are all relevant sections completed? Go through it with make a photocopy of the I-9 form and then go through with a highlighter and highlight every section that's completed and then look and see if something isn't. Excuse me. Is there any incorrect information? Does the information actually match the person's or documents? I've had it where the stapled documents had nothing to do with the person on the I-9 form. Any inconsistent information? Do more than one employee have the same Social Security or name doesn't match somewhere? That's a tip-off. Are the documents proper ABC documents? You might have somebody who accepted a Mexican driver's license. It's not a proper document for identity purposes. Do the documents, if copied, raise any concerns? That is, looking at those documents, do they show anything on there that makes you suspect the document is false? For example, as I said, the document written in crayon, or where there's actually a code on the form, most forms, which will correspond to the employee's birth date on the document, and sometimes those don't match. You wouldn't know it unless you knew where the code was, but those are things. If you've dealt with a lot of them, you'll know what I'm talking about. And you'll see that, and you'll know it's a problem. There are sample pictures of documents that are in the M274 that you can look at. They are good. They're very helpful. They're not the whole picture because sometimes there was some local variation in the type of documents that were used. So sometimes when in doubt, it's best to talk to counsel. What to do when you find problems? Well, I would suggest doing it the same way ICE does it. Identify by form, section, and type, breaking it out. What are these issues? Here they are. Then with form section 1, you're going to have to go back to the employee. Let's say you didn't fill out section 2 with respect to what documents and there are no copies. Well, that might be somebody that you have to re-verify with a new I-9 form and staple it to the current one that you have. And then make a note as to what you did. And then do with that the same thing for every single employee with that problem. Because if you got one, you probably have 4 or 5 or more that are like that. Errors in section 2 and 3 should be corrected by the employer, preferably the same person who completed the I-9 in the first place. And let me reemphasize this again. Do not ever backdate any information on a form. And any time you make a change, you're going to annotate it. Do not ever discard or destroy an existing I-9 form, even if it's wrong. You can complete a new one, or you can correct the information. If you complete a new one, you staple it to the old one, and you put a note as to why you did a new one. Okay? Do not throw one out. If it's found out, you could be severely penalized for that, because if the person is undocumented, that might be a basis on which they charge knowledge. You don't want to be in that situation. Correcting errors. If the information is missing on the form and the correct information is known, the information can be added to the form provided it's possible to identify the addition as a correction. So what you'll do is, if the A number is missing and you have the A number, which is the alien number that they get, and it's on the documents that they would provide you typically, you can add that in, and then you'll put an annotation to the side, which says, added A number, the date, and then your initials, preferably in a different color pen. If there's incorrect information, if the Social Security number is written wrong or the A number is written wrong, draw a line through it, then correct it, and then put the annotation in the different colored pen. And you must always annotate it with a date the correction is made in the initials. If there's multiple changes that you're making, prepare a note. If the I-9 is missing, do a new one. Get the new form, do a new I-9 for the person, and then include an explanation signed and dated. These are all important steps that you can take. If no documents were recorded or unacceptable documents attached, you're going to need to redo it. if the wrong version of the form is used, you can correct it by simply signing a new version of the form and stapling to it, or you can do the old form and you can annotate the old form with a correction. This is according to CIS guidance that was given to the Immigration Lawyers Association. And if there are multiple errors, a new form may be an error, but I would suggest speaking to an attorney first. USCIS guidance materials, I've already told you about the M274 handbook. You should have that available to you. Print it out, download it, have it available, read through. OSC guidance for employers conducting internal employment eligibility verification. This is a document that's available off of USCIS websites. You can search it and it'll come up and you can download it and print it. It's very helpful. It has a lot of helpful Q&As to tell you about problem areas that may not be answered by the M274. There are free seminars that are available on the USCIS website. You can download them and watch them. And they have a thing called I-9 Central, which is a website, a portal essentially, that has all kinds of Q&As on I-9s. And that's helpful to use as well. Sometimes USCIS will provide clarifications through the American Immigration Lawyers Association. They do that through routine conferences that they have where problem issues are raised and discussed, and then sometimes we get guidance. Sometimes that guidance can be contradictory, as was the case earlier this year with respect to regulations addressing automatic extensions of employment authorization documents and when a particular regulation went into effect and when an extension was filed. The question was whether if somebody had an extension pending at the time the regulation went into effect, whether they got the benefit of the automatic extension. And believe it or not, the regulations and the guidance in the conference were totally opposite. So sometimes you have to sort of buckle down and make a notation on the form or something to say this is what we're following and we'll stick with it through thick and thin. I went back, sorry. Now, let's look at some difficult cases. We have an employee unable to present document within the time frame set by the employer. Well, you're going to have to go back to that employee within 3 days. If they're not, then you're going to have to suspend them pending them providing the documentation. There's just no other way around it to avoid sanctions. Oftentimes, this is where you get the receipt that's not a receipt within the definition of the rule. The employee confesses to you that she's provided false documentations previously, but now has proper documentation. Well, in that case, I would typically say, well, have the employee complete a new I-9 form provided with a document list, and then re-verify them based on that documentation and staple the new form to the old form. Employee tells you she's unauthorized, but working with an attorney. Well, that's not quite the first one. And that suggests to you somebody who's not authorized and probably is going to have to be terminated. And the last one is, what if you get tips that an employee is unauthorized? A lot of times these are BS, and you need to be aware of that. Sometimes it's based on family feuds, and I've encountered these situations quite often. But if the information appears valid and genuine, or at least is verifiable in some way, then you may need to act on it. And that means looking at the source of the tip, looking at the specificity of information, and then looking at your paperwork and documentation. And if you have questions, talk to an attorney. So those can be all things which could potentially set you up with issues of knowing hire. So you need to be aware of them and respond to them, and don't ignore them if they come up. So looking forward, what do we have? Well, we have certainly stepped up enforcement. We have much higher penalties, which is going to increase the likelihood of litigation over fines, which is going to be very expensive for small employers and organizations. We have tightening of traditional categories of workers. The H-1B, for example, has seen a significant tightening of the standards, which could result in more people falling out of status or losing their work authorization. We have increased consular scrutiny, border and protection, and ICE scrutiny that may result in somebody being denied entry to the United States, being given a limited period of admission, or being in a position where you may find they're not even able to get a visa to come to the United States. And then we have disappearing employment authorization, DACA, which is the Deferred Action for Childhood Arrivals, TPS, which you should have read about being recently taken away for Nicaragua and Haiti, and then El Salvador and Honduras will be next in the thing. And those people will be having expiring work authorization, which they cannot renew. And then there has been concern about STEM, and that refers to science, technology, education, and mathematics. Those are particular students in F1 status who have work authorization that can be extended up to 26 months. And those individuals, there has been some discussion whether CIS is going to cut back on that rule as well. So in addition to all of the pressures on you of making sure your I-9 is complete, you should at least be keeping abreast of changes that are occurring with respect to employment authorization categories, because that could affect how your workforce changes and could affect who you can keep employing and whether some people are going to have to leave after a certain period of time unless they have extended work authorization. So with that, I'm going to flip this over to questions. And I'll be happy to answer any questions that you have.
Great presentation, Peter. We'll begin the Q&A portion now. Please enter any questions into the questions box of your control panel. We do have a couple of questions, and our first question is, if an employee provides a license that does not match the address on the I-9 form, can we reject the document?
If the license has a photograph of the individual on it, which it should as an identification document, and that photograph matches the individual that you're employing, that you can confirm the identity based on the photograph. I would ask the employee about the discrepancy between the driver's license and the address given on the form. If they have given a P.O. box, that may be appropriate, even though there's an actual address on the license. But I would give the employee an opportunity to explain it. In all likelihood, they're going to explain it. I don't see that as a basis on which you would necessarily want to reject that specific document. There may be other indicia that suggest it's a problem, in which case I would send a copy to counsel to review and discuss to see if it's something that you want to specifically reject. In some states, they don't even issue licenses with new addresses. They simply give you a little card to fill out with your new license, with your new address on it.
Okay, thank you, Peter. The next question is, what do we need to do for remote hires in order to be I-9 compliant?
Okay. One thing that you will need to do is to have a designated agent who is able to act on behalf of the company in performing the employment verification. And that means you could hire a notary, although that's not necessarily required. But I would recommend having a short form which says, so-and-so is hereby authorized on behalf of X company to conduct the following, I-9 document inspection and completion, so that person has been authorized in writing to act on your behalf, and then have them actually, they would do it. That's all that's really required, is that whomever is doing the remote hire is specifically authorized to act on behalf of the corporation in doing the I-9.
Okay, thank you. We do have time for one final question, and that question is, if someone tells me they need sponsorship for employment, what does that mean, and are we free to reject her?
Sponsorship for employment typically means that the person may have work authorization, but they do not necessarily have work authorization to work for you. This comes up in the context of, for example, somebody who's got an H-1B visa and they're authorized to work with one company, but they don't like that company and they want to get a new job. What you would have to do in order to have that person work for you is to file an H-1B petition and get it approved before, you can have the person could port over to you while it's pending. But you're going to have to go through the time and expense of preparing and filing an application, which the filing fees themselves are going to be close to, depending on the size of the company, could be over $2,500. So that's just filing fees, and you're going to look at between anywhere from $2,000 to $3,500 in fees for preparing the H-1B petition from an attorney. So that's a substantial expense, and you are free as an employer to say, we're not going to take the time and effort to sponsor somebody. We're not interested in that. So therefore we're not going to move forward on your application. So you would be free to reject somebody in that case. Okay? All right, if there are no further questions then, I want to say thank you to everybody for listening in. I hope this was informative. The goal is to at least get out there the information that you need to know and be aware of the current changes. If there are any further questions, you can feel free to contact me. I'd be happy to talk with you and give you some further guidance, and also check our website, as once these events happen, I will be adding notes to our website, the front page, that will explain if there's a change to the form, if there's a change to the regulations or something of that nature. So there's always information available. Thank you very much.